5 seconds to go. Start. The registration certificate, however, was not placed on record. On this aspect, it was the further submission of the respondent that it is only in the aforesaid title description that the complainant is described as the managing director of the company, but in the body of the complaint it is not so mentioned. The trial court acquitted the respondent on 12th March 2009 based on a dual reasoning. There was no document except the promissory note signed by the respondent to show that the loan was being granted, and the board resolution itself was not signed by the board of directors. It may be stated that this was really a true copy of the board resolution. The appellant preferred an appeal before the High Court. The High Court, by the impugned order dated 3rd August 2015, dismissed the appeal. It may be relevant to note that the High Court traversed many paths while coming to this conclusion. In a nutshell, the reasoning was, it could not be said that the complaint had been filed by a payee or holder in due course as mandated under section 142A of the NI Act. The payee was the company, and a perusal of the complaint did not show that the complaint was filed by the company. It had been filed by the appellant, who had described himself as the managing director of the company only in the cause title of the complaint. Probably a conscious choice was made to not file the complaint in the name of the company, as it was unclear whether the company was authorized to advance loans. We may note that the High Court did not give its imprimatur to the entire reasoning of the trial court, as it noticed that the demand notice was sent on behalf of the company. Thus, the company was aware that the complaint had to be filed by the company itself. It was observed that the aforesaid aspect was probably left vague on purpose by the company, and therefore it was opined that the complaint had not been filed by the payee in terms of section 142 of the NI Act. The appellant contended before us that it was quite apparent from the cause title of the complaint, which is an integral part of the complaint, that the same had been filed on behalf of the company. It was further contended that this was the reason that the board resolution authorizing the managing director to file a complaint for dishonor of the checks was annexed. The address given was of the company, which was the registered office address. The affidavit filed in the cross examination in pursuance thereto left no manner of doubt that the complaint was filed as the managing director of the company. It is the say of the appellant that there is a presumption under section 139 and 118 of the NI Act, which was not rebutted by the respondent. It was further contended that a duly signed check was sufficient to raise a presumption under section 139 of the NI Act against the respondent, as held in Triambak S. Hegde versus Shripad. It was not the say of the respondent in defense that the check was not signed by him or was signed under any fraud or misrepresentation. It was submitted that a very hyper technical view of the matter had been taken, and it only related to the format of the filing of the complaint and note the substance. The trial court itself had accepted that the complaint was filed on behalf of the company, as otherwise it would have refused to take cognizance under section 142A of the NI Act. The respondent had not even challenged the summoning order on the ground that the complaint is not filed on behalf of the company. Learned counsel for the respondent, however, contended that the appellant had failed to prove his case beyond reasonable doubt, and the complaint itself was not in a proper form. The complaint and the board resolution did not lead to a conclusion that it was filed on behalf of the company. The board resolution was also not signed by the directors of the company, nor does it find that it authorizes the complainant to file the complaint. The respondent also contended that no loan was advanced by the company, nor has it been proved as to whose account the alleged loan was advanced to. No loan agreement in favor of the company was placed on record. We have examined the submissions of the learned counsel for the parties. To decide the controversy, the relevant sections of the NI Act are attracted. Stop.